So this video is going to take you through how to do an application of judicial precedent question. So as per usual, we're going to start with that question. So we are advising Harry on the operation of judicial precedent, so not to be confused with statutory interpretation, and the way in which the courts may choose to avoid the binding precedent. So that's what we're looking for. This is the sort of thing that you could get at AS for 18 marks or A level for 15 marks. So let's have a look at our scenario now. So the XYZ College Student Code of Conduct states that students must wear blazers at all times whilst they're on college premises, or they will be suspended. In the case of XYZ colleges and student A, so remember our guy is called Harry, the courts confirmed that it was lawful for the college to suspend a student who removed their blazer whilst on college grounds, but the case concerned a student who took off their blazer because they didn't like the way it looked. This is a binding decision made by the Supreme Court. Harry is splashed with acid in the science labs and takes his blazer off to avoid being hurt. He's caught by his teacher and suspended. It's a bit harsh. Harry is now challenging his decision at the Court of Appeal. So there's nothing in a scenario question that is there just because the examiner wanted to fill a little bit of blank space. It's always there for a reason. And so the bits and bobs, the things that you go, oh, that's a strange detail to include, it's there for a reason. So we need to think about how we're going to go about dealing with that. So if we scroll on down, you will see that this is the structure that you are going to use in order to go through this. So you're going to start by defining, you're going to state stare decisis. And then you're going to give your definition as standing by the previous decision. You're then going to state ratio and obiter and explain the cases of how and gots and illustrate the difference between the ratio and the obiter. So we know that in R and how, it was a binding decision which says that murder is not a defense to duress is not a defense to murder, even, with an obiter comment, so a persuasive comment, that duress is also not a defense to attempted murder. And we know that that was followed in the later case of Gotts. The obiter in how becomes the ratio in Gotts, and therefore it becomes binding. And so now we have to think about, well, is there a ratio in the case that we've already got? Well, yeah, there is. XYZ colleges, the ratio, and this is your application here, the ratio is that it is lawful, so the college is allowed to suspend students. Was there any obiter comments in that case? Or nothing that was outlined. Now, it's really important that you briefly explain all of the relevant things. So you need to explain law reporting, and you need to say that this is an accurate outline of what happened in the case. And you're going to want to say, well, XYZ colleges, it would be really important for Harry and his legal team to look up that decision, because that's what the judge will do, and that will mean that that will be the binding precedent. So you can go back to your law report and look that up. Hierarchy of the courts. Now, this is very relevant to us here, and a lot of students didn't spot this. So we are told that XYZ colleges take the original case, and student A took place at the Supreme Court, and we are told that Harry's case is currently being heard by the Court of Appeal. So that is going to be extremely relevant to us here. So we need to say who binds who. Well, the Supreme Court is higher than the Court of Appeal. And we need to have a think about how that is going to be relevant by moving along and thinking about the practice statement and Young and Bristol aeroplanes. Now, this takes a little bit of thinking about, because yes, you will need to explain the practice statement created in 1966, and it allows the Supreme Court, House of Lords as it was then, to avoid their own previous decision where it appears right to do so. But you then have to say Harry's case is not yet possibly at the Supreme Court. So we need to have a think about young Bristol aeroplanes. So young Bristol aeroplanes, we know that there are, because this is a civil case, it's not a criminal case, so you don't need to worry about in the interest of justice and those sorts of things. For the criminal side, we're thinking about the civil side, and you've got your three exceptions where the Court of Appeal can avoid following their own previous decision. So per incurium, made in error. Is there a Court of Appeal decision made in error here? No, there's no Court of Appeal decision. If there is two conflicting Court of Appeal decisions, there's no Court of Appeal decisions. But what is relevant is if there's possibly a conflicting Court of Appeal decision and a Supreme Court decision, the Court of Appeal has to go with the Supreme Court decision. So actually, even with outlining the practice statement and Young and Bristol aeroplanes, Harry is still on this part of the facts likely to be held liable, and his suspension will be lawful. But let's have a think about our methods of avoiding precedent, because that's what the question really focused on. But in order to explain this, you have to have done your background about stare decisis, etc. So general methods of avoiding, when we say general methods, we mean any method that any court could use. So the Crown Court, the Magistrates Court could use some of these methods. So it's worth first of all mentioning that quite often, if you're going to respect stare decisis, the court will follow the previous decision. If the Court of Appeal chooses to follow XYZ Colleges and Student A, then Harry's suspension is lawful and will stand. Now, the smart ones of you will have figured out that the important one for us, the one that as Harry's lawyer we are going to be pinning all of our hopes on, is distinguishing. Because remember, he took his blazer off because he was getting burnt by acid. The other student that was in the previous case took the blazer off because they didn't like the way that it looked. Remember that we're essentially playing spot the difference. There are significant and substantial material differences within the facts of each of these cases, like in Balfour and in Merritt, and we can apply by saying it's possible that the judge in Harry's case will be able to distinguish it from the previous one. So moving along to overruling. Overruling is when a higher court changes the decision of a lower court in a later case. We've got a later case, but we don't have a higher court. We know the Court of Appeal is below the Supreme Court, so we can rule that one out. Moving along to reversing. Reversing is where a higher court changes the decision in the same case. So the way that you're going to spot the difference between the two of these is overruling, you're going to have two case names. So Davis and Johnson, Pepper and Hart. Two cases, one earlier, one later. Whereas reversing, something like Sweet and Parsley, you've got one case and a higher judge at a later point within the same case will change the decision from earlier. But our problem here is we know that our Court of Appeal judge is bound by the Supreme Court, and so this isn't going to be possible. For those of you looking to really stretch yourself, you may want to include disapproving. Now, that's not, strictly speaking, a method of avoiding precedent, is it? Because it's when the judge includes an obiter dicta statement disapproving of, saying we don't agree with the higher court's decision. And it will mean that potentially, as in cases like Ans and Merton, a later judge after this case today may change the decision in a future case. But that won't impact on XYZ Colleges and Student A, which is the current binding precedent. It also won't change the decision in Harry's case. So you're going to conclude on judicial precedent by saying there's the binding precedent, the ratio decidendi binding precedent in XYZ colleges and student A, which suggests that Harry's suspension is lawful. However, the best hope that Harry has is that the judge will distinguish, I should say, from the previous case, and therefore he might get a different decision. So have a go at writing your own answer to XYZ colleges and student A, and see how you get on. Did you spot all of those issues? If you didn't, have a go and have a look again.